Hi everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over appeals of court cases. So before I do that though, I'm going to qualify here, of course, that this video is going to be maybe 8 minutes, 10 minutes, something like that. Appeals generally are a very, very kind of complicated subject area. There are lawyers who spend their entire careers doing appeals, law firms rather, who do nothing but appeals, judges who do nothing but appeals. So I certainly don't mean to be exhaustive, comprehensive in this video, but I do hope to kind of educate the public a little bit about one common kind of belief about appeals that ends up not being true in most cases. So I will set the stage for you guys like this. So let's say that an individual is involved in a court case and maybe they're doing it themselves. Maybe the case is more complicated than they thought. Maybe the lawyer they hired is actually not so great after all. But basically, for some reason, like the person is discouraged about how the case is going, and they're thinking to themselves that, hey, I think I'm going to lose this because the judge didn't seem to like me, the jury didn't seem to like me, I lost this ruling, etc. But somewhere like in that mix, the individual kind of gets the idea that, hey, if I lose here, it's no big deal because I'll just appeal and just start all over again. Everything will be fine. I'll just, kind of focus my energy over there. And in general, that is not how it works. So an appeal sometimes will be considered a do-over, like you actually do literally start from square one again. But in the vast majority of cases, you don't. So believing that, if you lose at one level, like at trial, for example, you can just appeal and kind of do it over again, believing that is actually very, very dangerous because in general, you cannot start over. If you appeal, you can do some things over again, but not everything. You will be stuck with some of the things that the prior judge kind of decided or ruled upon. So that's kind of the short answer. The longer answer, I can give it to you also, it's no big deal. The longer answer, though, is that you need to understand the difference between two things. The first is fact, and the second is law. So I'll illustrate both of those with a kind of drunk driving example, I guess, because that's fairly kind of easy to understand, unfortunately. So a fact in a drunk driving case might be what happened. So, for example, was this person intoxicated? What was their blood alcohol level? How many drinks did this person have before getting in the car? When did they have these drinks? Where did they have them, etc.? So if you think of a fact, as you can probably guess, I guess from the name, a fact is something that actually happened. A fact will be determined by, evidence, documents, videotape, witnesses who saw the thing happen, experts who can kind of opine on why something happened that way versus something else, etc. So like a fact is going to be something that occurred kind of in the real world. So law, though, is going to be the significance of whatever fact actually happened. So, for example, going back to the drunk driver example, a fact might be how many drinks did this person have in the 2 hours or 3 hours before they got behind the wheel. So based on that, the fact, like another fact will be what their blood alcohol level was. The law will be what is the significance of that particular blood alcohol level, for example. So in California, intoxication is 0.08 or higher. So if, the fact is that, oh, well, this person's blood alcohol level was 0.09, the law aspect, the significance of that fact is that, oh, 0.08 and above means you are, drunk. And if your blood alcohol level, the fact here is 0.09, that means, the significance of that is that you are drunk under the law. So fact, on one hand, is what actually occurred, what can be proven, and law is the significance of what actually happened with that fact. So that distinction is important to understand because in the vast majority of cases when you appeal, you are stuck with the facts from below. In other words, if the earlier trial judge had a bunch of witnesses, examined a bunch of witnesses, reviewed a bunch of evidence, etc., that judge will have come to a set of factual conclusions. They'll determine, yes, the light was red, no, this person wasn't drunk, stuff like that. So if you appeal, in the vast majority of cases, you will be stuck with what the facts are. The prior judge's rulings about what actually happened will remain. The law, however, the law that the trial judge applied down below over here, that law will be applied brand new. So the thing is, the reason why people appeal is, Mr. Appeal Judge, we don't disagree with what actually occurred. We think that the trial judge applied the wrong cases. They interpreted these cases incorrectly, something like that. That's the reason why you appeal, because you allege that the trial judge applied the wrong law, applied the law incorrectly, and as a result reached an incorrect conclusion. You generally do not appeal alleging that the trial judge got the facts wrong. You can, it's no big deal, but the standard that you have to meet there is very, very high. You basically have to show that the trial judge abused their discretion and that there is no way for any kind of competent judge sitting in that same situation to have decided the facts as this particular judge did. Those types of appeals, though, are fairly rare. I would generally not recommend appealing based on that, unless the situation was very, very unique. In general, when you appeal, you should appeal because the law in your case was applied incorrectly or the wrong law was applied. So the kind of takeaway from all of this, I guess, is that if you appeal, you are generally going to be stuck with the facts from below. So to think that you are basically going to appeal and get a chance to start all over again with a clean slate, so to speak, is generally not correct. And it's very, very risky, actually, to do it that way, to think that way. So, again, hopefully that wasn't too confusing. Appeals, like I said, are very, very involved, very complicated. I don't do them, and they are a kind of specialized area, I guess. You definitely need need a lawyer who does appeals all the time to really help you if you are in a situation where an appeal is, likely or warranted. So, again, hopefully that wasn't too confusing, and I will talk to you guys next time. Thanks.